Hi, Michael. Thanks for coming on today.
Hey, Jason, thanks for having me.
Michael, there's a lot of companies right now being bought and sold. What are some of the issues you, as an experienced corporate lawyer, have to go through in terms of advising your clients?
So, Jason, a lot of times our clients are going through a transaction for the first time, and they're very comprehensive transactions. There's a due diligence process where a buyer comes in and kicks the tires and really looks over all different aspects of the business because intangible assets are often a key part of what they're buying. In the process of doing that, there's going to be a document that's going to have a bunch of representations and warranties describing the condition of the assets, tangible and intangible. As part of putting that together, there's inevitably a document that gets attached to the purchase document called a disclosure schedule, which lists specific exceptions to the condition of these various assets. The goal for buyer and seller is typically pay the purchase price for the seller not to have to give any of it back because the buyer can claim that something isn't as it was represented.
Right.
In putting together that disclosure schedule, many sellers are really surprised to see how comprehensive it is, as well as the fact that they have to break down their representations and warranties into at least two different critical buckets. One is a so-called fundamental representations and warranties. For example, things like if it's a purchase of the stock, buying the company through a purchase of the stock, that the sellers, the shareholders own the stock, they haven't pledged it as collateral to somebody else,
Right.
that all the shares are accounted for. That's really fundamental. Those representations last for a pretty long period of time because if they didn't get a release of lien from the bank or there's some other shareholder out there, that's a big problem.
Right.
The other bucket of representations and warranties goes to the operational condition of the business, financial statements, customer relationships, vendor relationships, intellectual property litigation, blah, blah, blah. Those so-called ordinary representations and warranties will last for a certain period of time after closing. There's a lot of negotiation between buyer and seller over how long fundamental reps and how long ordinary reps should last after closing. And in particular, what's the maximum exposure that the seller has? How much of the purchase price do they have to give back depending on the breach? What kind of damages have to arise? Who controls defense costs? Completely aside from this is sort of a worst case scenario for everybody in a transaction. It could be an M&A transaction, a joint venture, an LLC formation, where somebody's committed fraud. And believe it or not, when we're negotiating these documents, we want to define fraud under specific state law. Something, if I'm representing a seller, that says actual misrepresentation of a material fact with intent to deceive, that buyer is relied upon to their detriment. The buyer, on the other hand, if I'm on the buyer side, want a little more fluid definition of fraud, because if I've been really lied to and I've overpaid or I bought an empty bag of goods, I want to be able to pursue whatever legal remedies I can.
Right.
And it's really fair for that. So if you ever get fraud in a transaction, the contract isn't going to protect you. One of the worst case scenarios that can arise is if a seller or a buyer finds out that there is some fraud. Maybe it was done by one of their vendors, maybe it was done by one of their partners, maybe in fact they find out that they were, just to use a colloquialism, cooking the books. Now all of a sudden you got to worry about criminal exposure, and it gets much deeper when it becomes a type of fraud where you have an affirmative obligation to report it to the authorities. For example, violation of Foreign Corrupt Practices Act, we're dealing with sanctioned countries or people who are on a prohibited transactions list.
Yeah. How would you advise a client if they found out that they're about to go through this transaction? They've already kind of drafted a contract. Them themselves haven't committed any crimes, but they find out that someone in their own business has. So what do they do? Do you advise the other side of what's going on? Do you report them? Do you have themselves reported to the authorities? Like how do you advise that client to navigate the process?
It's a really hard question, Jason, because part of what is going on is the momentum of the transaction, the condition of the marketplace. If somebody discovers that somebody else is committing fraud, there's generally this emotional reaction of sort of shock. I can't believe he or she not just lied to me, but was trying to basically commit fraud on me, which is, like stealing. So you have to, I think, as a first part of that process is slow things down and create some time. We as corporate lawyers are not going to pick up the phone and tell the other side we think there's some fraud here. We are going to stop, try to create some time space with the buyer under whatever legitimate and truly honest discussions we can have with them about we're still working on due diligence, for example, we're trying to get that information. In the meantime, we want to bring in somebody who is familiar with dealing with cases of fraud, because when they come in, they are bringing a set of criminal tools to this in order to see who did what, when, how did they do it, how deep is it, and what are our obligations now that we know about it. There are a great many issues that come up in sale M&A transactions where the corporate lawyers, the deal lawyers can find solutions. That's where you are in a situation where you've got all the parties who make decisions at the table. If you have a fraud situation and if something criminal is going on, for example, your bookkeeper was stealing money from you,
right?
You have to bring in experienced criminal counsel to tell you, do you have to report it? What happens if you report it to the authorities? Once you report it to the authorities, you lose control over what happens with that criminal prosecution. If it were to be something, say, like a bookkeeper was stealing money, then it's still possible to move forward with a corporate transaction once you know the scope of the damage done, because it's essentially, look, there's something that the seller is entitled to get back from somebody who took money out of a bank account.
Right.
Right, and you may need to report it to the law enforcement authorities. Could be state, could be federal, and the deal transaction could go forward. But a buyer is obviously now going to be a little concerned because you're going to have to tell them something. And from our standpoint, in order to minimize the likelihood of a buyer coming after a seller after closing, we would want to craft, with the benefit of input from criminal counsel, what's the messaging to the buyer. And so we would try to then isolate that problem over here. If, however, the problem is not just somebody stole money from a bank account, but somebody really cooked the books and your financials are really messed up, right, that could jeopardize the transaction.
But on top of that, Michael, do you yourself advise a client to do their own due diligence on their own company prior to even putting it up for sale? Because that is going to be something that might be revealed later on.
Absolutely, Jason. I've been sort of advocating this for years with my clients.
Right.
Look, lawyers tend to be expensive. They tend to ask a lot of questions. Business owners oftentimes feel that it's a necessary evil to have to deal with lawyers. The reality is that it's better than a good insurance policy with a lawyer being involved, because if he or she is on their game, they're going to ask some questions along these lines to make sure the business owner, especially if they're thinking about a major transaction in the next couple of years, is asking the hard questions. Because if you wait until the buyer asks the hard questions, you might lose a market opportunity. For example, right now, the M&A market is white hot, and strategic buyers and private equity buyers are paying a premium for any company that looks like a good company for them to buy. So if you haven't done that pre-transaction due diligence, you're putting yourself at risk that something's going to come up during the sale or transaction process that could prevent you from taking advantage of a market timing.
Yeah, and I know this is a very outlier type of situation that we're talking about, but obviously you are trying to always prepare for it just in case, but it never shows up in your transactions, just to make that clear. But Michael, tell us when people should be contacting you. What type of things can you help people with, and when should they call you as corporate counsel?
So we get calls from clients. Oftentimes they tell us that they've been working either with a smaller firm that just wasn't as robust or on top of the range of issues that may be out in front of them. They haven't encountered them yet. They're over the horizon. For example, I'm working on a transaction now. It's a multi-state transaction. One of the things you always have to look at, if there's any sort of potential loan transaction element to it, is usury law and what's the penalty if you violate the usury law. I mean, there are states with criminal penalties if you violate their usury laws, and the entire transaction could be thrown out the window, in which case you're out. If you're on the, so to speak, lender side or seller side, you could lose everything. So the types of things that clients tell us that they appreciate when they've come to us is that we really challenge them to look at some of the fundamentals of their business as if they were a buyer. And so many times sellers or operators of business, and many of them are owner operators, are really comfortable with the risks in their business. They sort of know their customers, they know their vendors, they know their supply chain people, which is causing a lot of agita right now. And they can live with it. And they think, well, you know, anybody's going to buy my business and they should be just fine with it. The reality is that buyers, when they're writing checks, particularly if they're a bunch of digits on those checks, they want to know that they're not stepping into a problem.
Right.
Many times you want to have the most tax efficient structure to your transaction because the seller wants to minimize how much tax they have to pay. On the buyer side, the buyer wants to get the highest basis in the assets they're buying so they can start to depreciate from fair market value. So it's really important to be asking sellers, is it really true that your financial statements really are very robust, for example? And so we often start with that. We often start with supplier vendor contracts as well. That's where we get brought in, ask some tough questions about what happens if they're late, what happens if somebody was slipping somebody some cash to get something through customs. You ask those questions before you go to sell your business, as you're doing some of your seemingly routine transactions, and you just take the company to a higher level of sophistication.
That's perfect. And you guys are just experts in those fields. So I just really appreciate you coming on today, Michael, and I hope to have you back again soon.
Thanks, Jason. Really appreciate it. We're out there. Obviously, we want to help people, much like I know you do, in the proactive way.
Right.
So many times we as lawyers are put in a reactive mode where the horse is out of the barn, so to speak. And what clients should really appreciate, and any business person, is that having a good relationship with a lawyer that you trust, that is going to tell it to you straight, not beat around the bush, is really important. Having a lawyer that you just see as an expense, as a provider of commodity service, you are not really helping yourself get to the next level of where you want to be, professionally or personally.
Take care now, Mike. Thanks for coming on.
All right. Thank you.